One way in which law is divided up is a division between criminal law and civil law. The most straightforward way of looking at this is that criminal law is concerned with defining crimes and setting the available punishment for them, and criminal courts are the courts in which crimes are prosecuted and the offenders punished. These will be looked at in a later section of this resource. Civil law, essentially, is all other law. Many disputes involving civil law or actions for the enforcement of civil law requirements and claims based on civil law take place in the courts, which we will look at shortly. However, many civil law cases are dealt with outside the court system by tribunals, which normally operate in a way which is more informal than court procedure and often involve people who have a special knowledge or interest in the area where the tribunal has power. Examples of tribunals are the Children's Hearings, the Mental Health Tribunal for Scotland. This is an example of a tribunal with members with special expertise or interest. It is chaired by a lawyer with two other members, a doctor and someone with experience of mental health as either a patient or a carer. Employment tribunals, which deal with disputes about employment, for example claims of discrimination in employment, and benefits tribunals. There is a variety of these dealing with appeals by claimants about a variety of different benefits. Let's now look at the civil court system in Scotland. This has only recently been reformed by the Courts Reform Scotland Act 2014, though, as will be mentioned later on, the reforms have not all been implemented as of January 2016. At the bottom of the civil court ladder is the Sheriff Court. Scotland is divided up into 6 sheriffdoms, and each of these sheriffdoms, with the exception of Glasgow and Strathkelvin, is further divided into Sheriff Court districts, each of which will have its own Sheriff Court building. So, for example, Stirling is in the sheriffdom of Tayside Central and Fife, and in Stirling Sheriff Court district. The importance of these geographical divisions is that they help to determine which Sheriff Court has the power, or, more technically, jurisdiction, to hear a particular case. The basic rule is that a Sheriff Court has the power to hear a case if the person being sued lives within the Sheriff Court district for that court, but there are many exceptions to this. On this standard model, this means, for example, that Stirling Sheriff Court can hear cases brought against people who live in Stirling. There is one notable exception to this, in that there is a personal injury court which has been set up having jurisdiction across the whole of Scotland. Another peculiarity of this court, which is a Sheriff Court, is that cases can be heard by a jury of 12 instead of by the single sheriff as would normally be the case. At the moment, in January 2016, the Sheriff Courts are all staffed by sheriffs who are all legally qualified and have been in legal practice. The Sheriff Court can hear a wide range of court proceedings. It is the only court that can hear claims for money up to £100,000 and the only court that can hear actions for eviction. Applications from children's hearings for grounds of referral to be established, appeals against children's hearing decisions, appeals against decisions of the Mental Health Tribunal for Scotland, and applications for appointment of a guardian to an adult with incapacity all go to the Sheriff Court. In addition, it deals with most family law cases, divorce, contact with children, permanent orders, and adoption. As we've already said, in most cases there is a single judge. The slide also mentions summary sheriffs. The first of these will only be appointed, and to a limited number of courts, in May 2016. Their powers are more restricted than those of sheriffs, but include applications relating to children's hearings, adoption applications, and other family law cases. The next court is the Sheriff Appeal Court, which hears appeal from the sheriff or summary sheriff. This only started work in January 2016, and before that, appeals from the Sheriff Court either went to the Sheriff Principal, who also has responsibility for the overall administration of a sheriffdom, or to the inner house of the Court of Session. Situated only in Edinburgh, the outer house of the Court of Session is, like the Sheriff Court, a court of first instance. That is, a court to which a claim can be made and which will take the first decision on the case. It consists of a single judge, except very rarely when there is a jury of 12, as happened, for example, in the Tommy Sheridan defamation case, and is the only court that can deal with certain types of claim, most relevantly for our purposes, judicial review. The inner house of the Court of Session is, for all practical purposes, an appeal court. Usually 3 judges sit to hear appeals from the Sheriff Appeal Court or from the outer house. Finally, the Supreme Court of the United Kingdom, based in London, hears appeals from the inner house.